everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others, as always. For today's video, we are talking about an article that is positing how 6 states could overturn the 2024 election. I do like how we haven't even had the election, and we're already contemplating the election is stolen, but only, of course, if the vote is one way. If the vote is one way, then the election is not stolen. If it's done another way, then the election is stolen. Seems to be the message of these things. But the Supreme Court apparently may let state legislatures decide the presidency. Yes, because the Constitution kind of says that, in almost exactly those words, by the way, that each state shall choose the manner of the electors. Late last month, in one of its final acts of the term, the Supreme Court queued up another precedent-wrecking decision for next year. Exciting. The court's agreement to hear Moore v. Harper, a North Carolina redistricting case, isn't just bad news for efforts to control gerrymandering. Okay. Not for nothing, but the Supreme Court has to hear redistricting cases. They actually don't have a choice. Not that this article would know that. But yeah, the Supreme Court, most of the cases, of course, it gets are through what's called a writ of certiorari, which is discretionary jurisdiction for appeal. But the Supreme Court, they do actually have to hear some cases by law. And one of the cases they have to hear is redistricting cases. It's not called a writ of certiorari. It's just called an appeal. Because what you do in a redistricting case, you see, is you have a 3-judge district court. So the trial court is 3 judges. And then the Court of Appeals is the Supreme Court. So the Supreme Court can't do anything else other than hear this case because of that. So, yeah. Anyways, the court's right-wing supermajority is poised to let state lawmakers overturn voters' choices in presidential elections. The Constitution says almost exactly that in those words. To understand the stakes and the motives of Republicans who brought the case, you need only strategic fact of political arithmetic. 6 swing states, Pennsylvania, Michigan, Wisconsin, Arizona, Georgia, and North Carolina, are trending blue in presidential election, but ruled by gerrymandered Republican state legislatures. No comparable red trending states are locked into Democratic legislatures. Although, for what it's worth, the Democratic states are trying to do this too themselves, which I'm sure this article is not going to mention. It's just a little bit different. The Democratic states are trying to do something called the National Interstate Voting Compact, where the states, if they get enough states to agree, would agree that their state votes will go to the winner of the national election, which means, for example, that California, because it's one of the members of this coalition, would be in a position where it would vote for a president other than the ones that its own citizens voted for, because that's what that would mean, right? Rather than us vote according to the way our citizens want in our particular state, which is how they do it now, we would be voting according to how the national vote turns out, which means that we'd be voting against our own state. So the Democrats have been trying to do this for a long time. They want to get 270 electoral votes together so that they can have their national interstate voting compact, so that they can, without constitutional amendment, change us from electoral voting system into one where it's just winner takes all nationally, because they would basically be assigning their electors to the national winner. So the Democrats have been trying to do this forever, but the Republicans, apparently, if they're going to try to do it in some other way, that's really, really bad. Okay. Joe Biden won 5 of those 6 swing states in 2020. Donald Trump then tried and failed lawlessly to muscle the GOP state legislatures into discarding the victory and appointing Trump electors instead. It wouldn't be lawless. The Constitution says the states get to choose the method of the electors. So it seems to suggest just flat out, yes, if the state legislatures want to, they can just assign their electoral votes any way they want. The Moore case marks the debut in the nation's highest court of a dubious theory that could give Republicans legal cover in 2024 to do that just as Trump demanded. Also, incidentally, might give the Democrats cover to do it for them in their national interstate voting compact thing. And if democracy is subverted in just a few states, it can overturn the election nationwide. Republican lawyers taking note of the structural advantage in battleground state lawmakers set forth in independent state legislature doctrine. That doctrine is based on a tenuous reading of two constitutional clauses, which assigns control of the manner of congressional elections and the appointment of presidential elections in each state to the legislature thereof. Yes. Now, these two clauses should be read a little bit differently. So yes, the manner of elections and how they're conducted, and then also the appointment of presidential electors, and it says to the legislature thereof. It sure does. Based on that language, the doctrine proposes that state lawmakers have virtually unrestricted power over election and electors. Now, they might need the governor's approval or otherwise get past a veto. The real challenge would be, can we do this without doing that? Can we do it just by the legislature voting? So it would just be the legislature voting it without participation by the governor, for example. Could you do that? That's the challenge, and that part is much less clear. State courts and state constitutions, by this reading, hold no legitimate authority over the legislature in their conduct of U.S. constitutional functions. So the idea would be that the Constitution, the federal Constitution, is giving the state legislatures independent power that can't be checked by anything else because it's derivative of the federal Constitution and can't be limited by state constitutions. Okay. This is a genuinely radical proposition. It's never been accepted by any state or federal court, and the Supreme Court itself ruled as recently in 2019 in Rucho versus Common Cause that state constitutions can provide standards and guidances for state courts to apply in redistricting cases. In another redistricting case 4 years earlier, the court confirmed long-standing precedent that legislative powers are defined and controlled by state constitutions. That definitely makes sense. The idea that the legislatures stand unbounded by any limit from their own founding documents is a fringe debating point invented for Republican political advantage. Yeah, I mean, if you take it this far, then yes. So can they do it with the legislatures with approval from the governor? Yeah, because that's basically how you make a law. Can they do it acting on their own? No, probably not. Can they do it without it going through the court system in their own states? No. But this is kind of where they're trying to go. So some of these ideas are a little bit more fringe than others. This is fair. The nature of what the legislative power is within every state is going to be informed by the state constitution and what the legislature can and cannot do. It's not even necessarily uniform in terms of those procedures. So yeah, it seems a little bit unlikely to completely disconnect it from state level legal authority, but okay. Even so, 3 justices, Samuel Alito, Neil Gorsuch, and Clarence Thomas, have spent 2 years campaigning for the independent state legislature doctrine in judicial statements and dissents. None of those writings carry the force of law. No, they wouldn't, or we wouldn't be having this discussion. But together they served as invitation for plans to bring their case in a suitable purpose. This is true, and this is what the Supreme Court typically does, or it's very common to do. A justice who's unhappy with whatever situation will say they would like to see cases of a particular kind. And then it becomes an invitation, obviously, to try to meet that concern. So, yeah, justices will often say in their dissents, all kinds of justices will say, we wish we could had cases that would resolve some particular issue. So, yeah. A 4th Justice, Brett Kavanaugh, wrote in a concurrence in which he invited the North Carolina Republicans in the Moore case to return to the Supreme Court after losing an emergency motion. That would be like an injunction, and those things are extraordinary relief. So, how about the non-extraordinary relief version? Yes. Whether John Roberts and Amy Coney Barrett stand on the doctrine is unclear. The immediate question in Moore is whether the state Supreme Court, applying the state's constitution, can override the legislative choice on the matter of drawing election districts. Until ISL came along, the long-standing answer was yes. But advocates of the independent state legislature doctrine have their eyes on a bigger prize, the presidency. So the question is, in drawing the legislative districts, which might go to the manner, time, places of elections, does the state Supreme Court have the power to overturn those districts because they're not in accordance with state law? Or does only the U.S. Supreme Court have power because only the states can choose the methods of election? So what role, if any, is there for the state Supreme Court? Because to what degree is this a function of state versus U.S. Supreme Court law? So, yeah, that's a pretty interesting question for the U.S. Supreme Court to resolve for sure. If you give the legislature a blank check on the manner of appointing presidential electors, then a Republican majority could, in the most muscular version of the independent state legislature doctrine, simply disregard of Biden victory in the state's popular vote and appoint Trump electors instead. Yeah, I suppose they could, but of course that would lead to huge political consequences for those state legislatures, so yes. Even this Supreme Court might not go that far. It might acknowledge that once having passed a law providing for a popular vote for president, a state legislature could not strip voters of that power after they voted. But in that case, ISL still offers plenty of room to overturn the people's will. In litigation over the 2020 election, Texas and other Republican-led states showed exactly how the argument would work when they asked the Supreme Court to block the certification of Biden electors in 4 swing states. Texas argued the election results in Pennsylvania, Georgia, Wisconsin, and Michigan were unconstitutional because executive and judicial officials made significant changes to legislatively defined election laws, and that lawsuit from Texas was dumb because, of course, it had no standing in those states. The Supreme Court made no ruling on the merits because they had no standing. Right. Texas can't complain about what's going on in other states. That's a matter for that state, not Texas. But if the Supreme Court adopts the ISL doctrine and more, the argument that Texas made will become a model in 2024, only for those states internally. The conditions that Texas cited in its argument are almost always present in contemporary elections. Legislatures pass laws on the conduct of the vote, but election administrators have to interpret those laws and set implementing rules such as precinct locations, polling times, and counting procedures. State courts sometimes mandate change in the rules to comply with state constitutions. It's all but impossible to conduct a legislation with an election without making rules or choices the legislature did not specifically authorize. Maybe the legislature should just legislate harder, though. The pernicious threat of the independent state legislature, wrote Richard Hansen, an election law expert at UCLA, is that a state legislature dominated by Republicans and a state won by Democrats could simply meet and declare the local administrators or courts have deviated from the legislature's own rules, and therefore the legislature will take matters into its own hands and choose its own slate of electors. If they did that, one would imagine that would come with significant political consequences for the members of those states, which is one of the reasons that, as a practical matter, you would imagine this is not likely to happen. But in commentary on the Moore case, former White House counsel Bob Bauer and Harvard law professor Jack Goldsmith identified another legal threat to presidential elections they regard as more serious. Okay. According to the Electoral Count Act, state legislatures may disregard presidential voting results and appoint electors instead by declaring the voters have failed to make a choice, a phrase that is undefined in the law and was exploited in rogue vote-stealing efforts in 2020. And the Republicans, of course, wanted to fix the Electoral Count Act, but the Democrats didn't let them because they wouldn't let them do it without fixing a whole bunch of other things the Republicans didn't want to fix. So even though they kind of both agreed to fixing the one thing, the Democrats wouldn't do it without fixing everything. And the Republicans didn't want to fix the other stuff. So a legislature could seize on any irregularity or baseless allegation of fraud to claim voters have failed to make a choice. This scenario is gravest if Republicans win back the House and Senate in November. Okay, so we do have problems with the legitimacy of elections if those elections don't go our way, it seems, according to this article. It is the job of Congress to make a formal count of presidential elections, and the political interests of GOP-led House and Senate would align with GOP state lawmakers who appoint the electors. As opposed to if the Democrats gained all this power, which would never do any of these things. Okay. That is where reform of the Electoral Count Act, a 19th century statute, comes in. The Republicans wanted to reform the act. The Democrats wouldn't let them do it unless they agreed to a whole host of other things, and so it doesn't get fixed. I've written before at length about flaws in the law that leave the nation at the risk of a broken election. A bipartisan group of senators led by Joe Manchin and Susan Collins released a draft bill last week that will make it harder for state lawmakers or Congress to subvert a presidential election. Prospects for the bill's passage are unclear, but the draft would make several valuable reforms. For one thing, it deletes the whole provision about allowing lawmakers to appoint electors if the voters have failed to make a choice on Election Day. Instead, it mandates that electors shall be appointed in each state on Election Day in accordance with the laws of the state enacted prior to Election Day. That clears up an important ambiguity and forbids a state legislature to change the rules after voters have counted their ballot. Of course, we could still get into the issue of whether or not that's lawful or not, because if the federal constitution gives it to each state the power to choose their electors, then maybe this portion of the Electoral Vote Count Act would not be lawful, but that would have to be another vote for another time. The draft also attempts to ensure there can be only one valid slate of electors certified in each state, specifically that the governor is, usually, the certifying authority, and gives jurisdiction to federal courts to certify a slate of electors if the state fails to do so. That's tenuous, because you're going to let the states have the power to choose the electors. You're going to let the federal judges choose the electors. That's tenuous on the constitutional language. If Congress passes the law, it would be agreeing to accept as conclusive the state or court's decision on whether electors to certify. Okay. Some of the nation's leading election law scholars have welcomed the bipartisan draft, but it's unclear whether the Supreme Court's rights wing would accept the rewritten statute as constitutional. I know, because as I pointed out, there's some potential problems here in the constitutional language, right? The Constitution says the state's legislature shall choose the manner of elections and shall choose the electors. So, yes, questions like, is the state Supreme Court part of this? Is the state constitution part of this? Is a federal statute a part of this? Are not trivial questions, because the Constitution seems to suggest that it's up to the state legislatures, and so if it's up to the state legislatures, it's necessarily not up to the federal legislature, which might make this portion of the Electoral Count Act unconstitutional. I don't know whether it does or not, but it might, because the Constitution seems to suggest that. The Collins-Manchin bill arguably strips Congress of power it holds under the 12th Amendment to decide which electors to count, which would also be another reason to rule to be unconstitutional, violates the 12th Amendment. That's also a problem. And the court might decide that Congress cannot relinquish those powers. Proponents of the independent state legislature doctrine, meanwhile, may be skeptical of giving a final say on certification of elector to a governor or federal judge rather than a legislature. The federal judge thing is particularly problematic because it's not a state official. Alito, Thomas Gorsuch, or another justice might likewise be unwilling to accept that Congress can prevent state lawmakers from appointing an alternative slate of electors when the outcome of the election is in controversy. That the language of the Constitution does seem to suggest that it's up to state legislatures to make these choices. The degree to which they're independent of the governor, for example, is open to interpretation, but I mean, that is the language of the Constitution. Whether or not Congress decides on statutory reform, more could set the stage up for a major shift in voting law in the run-up to the 2024 election. The court's right wing appears to be spoiling for that. Under traditional norms for granting certiorari, the Supreme Court would not even put the case on its calendar. The petitioners, led by Republican Speaker of the North Carolina House, never made the ISL argument during their state trial, and legal parties ordinarily cannot raise questions on appeal they've not raised below. According to the latest proposed schedule, the Supreme Court won't hear more sooner than December. On its face, the case will be moot by then. The North Carolina redistricting map only applies to the 2022 election, which will take place the month before. Nor is there significant conflict in opinions in the lower courts for the justices to resolve. None of the factors restrained the Supreme Court's right-wing justices, Just as they did in overturning Roe versus Wade, a ruling they need not make to uphold the Mississippi abortion law, the right-wing justices seized on the first available vehicle for the paradigm-shifting decision. Nothing will come of it. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.